Lindsay, I'm not sure if you were trying to say something, but you're muted.
Yeah, no, I was trying to talk to my assistant on a different line.
I apologize. I saw your mouth moving there. Okay.
Thanks,
All right.
Steven.
All right.
three calendars that we're going through. We have the default no service calendar. We have a regular non-jury calendar, and then we have a very short, I hope, recall of a couple of cases on the trial calendar. Since that's the shortest, I'm going to start there. So we're going to start with going through the trial calendar, which I just have, I believe I'm just getting some announcements. And once we finish that, we'll figure out what else is here, and I'll call the other calendars and see where we're at. All right, so Ms. Gant, you're here on Duncan versus Wise.
That's right. Good morning, Your Honor.
Okay, good morning. How are you?
I'm good. How are you?
Doing well. Did you happen to get, I'm going to turn it down. That's on me. Did you happen to get a chance to speak with Mr. Smith and figure out kind of where, like what a time frame might be on where y'all are at on the probate administrator?
I did not, Your Honor. I reached out and voicemail with the office and didn't hear back.
Okay. I can't turn it down anymore. I don't know what's going on there. So, okay. Well, then I think what I'll do is, I think I'm just going to do the same thing I did for today, which is to say, I'll just have you report virtually on August 12th,
Okay.
unless y'all can send us an email saying, you know, here's where we're at. So, and we'll reach out to Mr. Smith on our end as well with an email and just say, you know, hey, look, we just need an announcement. That's what we need. So,
Perfect.
okay, perfect. That'll work. All right, so, and I can see Ms. Billiers is here, so that means you're off the hook on the second case, so.
Thank you, Mr. Honor.
Yeah, it's great to see you. Thank you very much.
Thank you. Have a good day.
All right, hold on a second. Oh, I already told you. Yeah, and he was just saying to remind you of the Fayette case, but we already talked about that we're going to get that lined up probably before the end of the year, so.
Sounds perfect. Thank you so much.
All right, thank you.
All right, bye-bye.
All right, Mr. Fair from the beach and Ms. Billiers. So Mr. Fair, thanks for jumping in today. Again, my goal is to kind of get us organized to move y'all's case to a more definitive spot. And of course, I've got the interpreter issue that I'm sorting out on my end. And then who had the expert witness issue?
I do, Judge.
Okay.
Good morning, Judge.
All right.
And I'm getting a lot of feedback. I don't know if everybody are just listening.
I'm having major volume issues.
Okay.
So literally up here, it says everyone is muted, which makes no sense to me at all. And I've never seen it in my entire, we've been using a version of this system since 2018. I've never had it do this, but it also had several new options this morning. So apparently a software update went through over last night. So anyway, I guess I'll have to pivot back to IT mode. So just whisper and I'll do the same.
Judge, I emailed Mr. Hope and Mr. Fair and let them know that my office was in contact with family member of Dr. Griggs, and Dr. Griggs is an expert who's on medical leave.
Yes.
They're saying realistically they expect him to be able to sit for a evidentiary deposition in December.
What was the date again?
They said December.
Okay.
This year.
Okay. So that's the information I needed, because obviously I don't want to line up the interpreter and then obviously have that, because it's such a nuanced language. We can only find one certified interpreter, and we're trying to talk with Language Line. See if maybe I've never used Language Line in a trial, although we've used them often in just the courtroom when somebody wanders in. And so we're trying to figure out how that might look if we need that as well. So, okay, well, I tell you what, I'm going to, I don't know if we have everything else. Let's see.
We had, Steve and I had corresponded and each have agreed to some motions of committee and objected to other. So we let Mr. Hope know, which we have the objection.
No, I didn't catch any of that. Say it one more time.
Can you hear me?
Yes, you just broke up a little.
Maybe I can maybe you can hear me better. Hear me better?
A little bit.
Okay.
I think
Okay.
all this is on my end.
All right, well, whatever it is, council and I have exchanged MIL objections, and obviously we have some arguments to make. But we've agreed on a bunch and filed objections to a few others. So that's where we are as far as the MILs are concerned.
Okay. So we need to get those heard, is that correct?
Yeah, prior to trial, obviously.
Okay. All right, so we'll do that on your next calendar call. So just send us what you're agreed on, and I'll remove that from my list. And then we'll hear what needs to be heard at your next calendar call.
Okay.
Judge, are we continuing from the current calendar call so I can advise my client of the same?
Yes, I just wanted to have this conversation before I officially said you're good to go. So.
All right, thank you, Judge.
All right, so if y'all will, so here's what we'll do. We're going to tentatively put this on the December calendar. Y'all keep us updated on your expert. I'll keep you updated on my search for an interpreter. If it doesn't make December, it'll go to February.
Okay.
Thank you, Judge.
And
Okay, I appreciate it.
And we'll swap with the actual dates and all that. And again, we've got good lines of communication, which is why I'm very comfortable saying we'll figure these things out as we go.
Okay.
All right, Mr. Fair, you go
Good to
back to
see
the beach
everybody.
now. Thanks for coming in on your leave.
All right, take care.
All right. Bye, everybody. Thank you.
Bye, y'all. Okay, don't know what's going on with the volume today, but I have to be a judge, not an IT guy, so we're going to just keep moving. So, all right. What I want to do next is I want to call the non-jury calendar. I want to see who is here, and I want to see kind of what we're looking at. So we're moving over. Everybody's got their non-jury calendar out. So here we go. So the first case on the calendar is 22 SV 40, No Bills versus Rosado. Who is here on that?
Your Honor, Michael Clevero for the plaintiff. That's a motion for attorney's fees pursuant to 9/11/68. I anticipate 10 minutes.
Okay.
David Salmons here for the defendant, less than 5 minutes, Your Honor.
Do y'all want it taken down?
I don't need it recorded, Your Honor.
I don't know.
No? Okay. All right, no takedown. Okay, next case is 22 SV 67, Alford versus Walden. Is here on that. Is this the case with the representation issue that we talked about? Okay, we thought that was it. All right. So, all right, who's here on who?
Jim Rice here on behalf of the plaintiff, Tim Alford. John Caldwell here on behalf of the defendants, and they are also present on behalf of themselves.
Yes. I remember directing everybody to be here. So,
Robert Mills on behalf of Mr. Alford as the counterclaim defendant, Your Honor.
okay, I'm glad you're here. Thank you for coming. So, all right, y'all, how long do you think y'all need for all aspects of this hearing?
I have a pending summary judgment motion, 10 minutes maybe.
Okay.
Your Honor, we have, pursuant to the court's order, filed the motions in limine. Just to not put too much in front of the court, but Mr. Caldwell, the defendants on the personal bodily injury claim for Mr. Alford have experts now, and we work together to get those scheduled.
Okay.
So,
I knew we were going to have a lot of housekeeping, so this is okay.
okay.
So yeah, I knew we had a lot of housekeeping because we're going to have new counsel come in, and we had sorted it all out. So do y'all want this taken down? I guess is the key question.
No, I do not.
Okay.
I have it as it relates to the summary judgment motion, Your Honor.
All right. Well, y'all just sit tight then, because again, I think y'all are going to take a bit, but I think that's just because we have a lot of steps to go through. So. All right, if you'll help him shut that off. All right, 23 SV 202 Hart versus Briggs.
Good morning, Your Honor. Vivian Chatel for the plaintiff.
Welcome.
Good morning, Your Honor. Cullen Mason for the defendant.
All right, this is a motion to set aside default, correct?
Correct, Your Honor. That's my motion.
All right, so how long do you think this will take?
Conservatively, Your Honor, I'd say about 15 minutes.
Okay,
I would say 15 minutes as well, and we would like it recorded.
all right, take down.
Us as well, Your Honor.
Okay, perfect. Y'all sit tight, thank you. All right, then we have 23 SV 412, Hortman versus Brightmore. Who's here on that one? Well, that's a surprise. This was motion to enforce binding arbitration. Did we miss something? Fantastic. Okay, they settled. Just want everybody to know how excited I am about that. That was our massive ringleader case this morning. It was going to be a long hearing on motion to enforce binding arbitration. So congratulations to them and us. Okay. And then nobody should be here on the next case, 24 SV 112 Madrigal versus Regency. We've already continued that one. All right. I love it when a plan comes together. Okay. So that's 2 of our 3 calendars. So our last calendar is the default and no service calendar. Is anybody here on the default no service calendar? If you're here, raise your hand for me. All right, how many cases do you think you have on it? Just ballpark.
Between 5 and 10.
Okay.
I have 7.
7?
I have 1.
Okay. All right. So what I'm going to do is, if y'all have work you need to do or whatnot, and you want to set up somewhere quiet, you're welcome to step back in the jury room. I'm going to finish the non-jury calendar first. If you want to come up and sit in the jury room, that's fine. If you want to go sit in the law library, that's fine. But I'll just tell you, just come back, about 10:30 or so. But I just want you to know there's bathrooms and outlets back here. There's 2 rooms back this way. You're welcome to go sit up in the law library. I just didn't want you to sit here and have to waste your morning. I know y'all have stuff to do, but I definitely won't get to y'all for just a little bit. So, all right. And if you decide later you do want to go there, you just go out this door and then back in this door here and into the jury room. So, all right. Well, let's pivot back to the non-jury calendar then. Let's start with Nobles. So 22 SV 40 Nobles versus Rosado. Rosado, excuse me. So plaintiff over here by the jury box and defense over there farthest from the jury box. Give me a minute to pull your case up. And if anybody wants to go to the law library, it's up on the 3rd floor on the other side. Mr. Hope did a very good job renovating it. I think you'll be impressed. Okay, once y'all get settled, there's no takedown on this, but just to make sure I have everybody's names, if you'll give me your names again.
Michael Calabro for the plaintiff.
All right, thank you, Mr. Calabro.
David Salmons for the
All right, Salmon. All right, let me. Mr. Sammons, I was just looking for your entry, that's all.
This case, I was on the case. Another attorney came in, took over the case, and now I've just recently got put back on the case.
Okay.
I think I may be the fourth attorney on this case.
Okay, so you were still on
At
it.
least by-
You're supposed to be still on it is what I'm hearing that. Okay, well, how about this? We need to get your entry filed, for this to be right, because I don't know what we're doing next on this, so. So I'll need you to file that before you leave the building today. Can you do that for me?
I'll see what I can do.
So, you were substituted out, correct? For
I
another.
believe so.
All right, well, just get that entry filed today.
Okay.
Not today, before you leave, please.
Okay.
All right, so, so this is the plaintiff's motion for 9/11/68 attorney's fees, correct?
Correct.
Okay. In this matter, this was a bench trial with me, is that correct?
Correct.
This is coming back to me now. Okay, so, all right, well, it's your 9/11/68 motion, Mr. Calabro. So the floor is yours. You're welcome to sit or stand as you prefer. I don't have a jury, so I just want you to know that you're welcome to sit and use the mics or stand and use the lectern. I don't have a preference.
I'm used to standing and talking. If you don't mind, I'll sit.
That's why I want you to know you can do it. You can handle it however you prefer,
Do you need me to, usually I don't need amplification. Do you need me to talk into the microphone?
as long as you're loud.
I feel confident. On December 19, 2022, we served an statutory offer of settlement in accordance with 9/11/68. I attached a copy to the motion. It was delivered by the post office on December 27, 2022. A copy of the post office verification, all the post office verifications now are electronic. It was also attached to the motion. And so the 30-day period for which the defendant was to respond expired on January 26, 2023. The offer of settlement was in the amount of $20,000, and it was rejected by statute on Friday, January 27, 2023. The offer complied with the statute, and after the non-jury trial, the court awarded $25,711.30, and that exceeds the statutory offer of settlement by more than 125%. And pursuant to the statute, we're entitled to reasonable attorney's fees and expenses of litigation. I have two exhibits I'd like to tender to the court today. These are business records of the firm, billing statements. All right, approach, Your Honor.
You got to give Clint something to do, so got you covered, Clint.
The first is, this is our billing software program, and the legal assistant is separate than the paralegal and lawyer. It's just the way the software is done. But I'd like to state in my place that I've been practicing law in Georgia for 40 years, graduated Emory Law School in 1984. In fact, I taught trial techniques at Emory for 20 years. I've been a member in good standing of the Georgia Bar since then, representing personal injury clients in a wide variety of matters, including complex civil litigation, medical devices, product liability, premises liability, professional malpractice. And based upon my experience and education, my hourly rate is $400 per hour. That's my reasonable and customary rate. It's comparable to other attorneys in the area with similar experience and background. And the first exhibit, the exhibit with my time and my paralegal time. My paralegal, Jeanette Mahaki, I can safely say is the best paralegal in the state. I have no qualms about that. She's been practicing or been serving as a paralegal for 30 years at a variety of personal injury firms. We bill her at $125 an hour. That's a reasonable and customary rate, and based upon her skill and contributions, that's a bargain. She's just that good. And then all the entries made on Exhibit 1, which is the invoice for Ms. Mahaki and myself, were made at or near the time of the service performed, and they reasonably and accurately reflect time we spent on the case, and that the services were necessary to represent the client. Basically, these just represent trial preparation. We originally prepared for a jury trial, but the Friday before trial, the defendant consented to a bench trial. So there is a lot of jury trial preparation, which obviously takes a lot longer than preparing for a bench trial. Ms. Irma Riemann was my legal assistant at the time. She happened to be a certified paralegal as well. Her time is accurately reflected in Exhibit 2. She has not nearly as much experience. We bill her reasonable and customary rate was $50 per hour, and that's reasonable considered her skill and experience in the services she performed. And her time is accurately reflected in Exhibit 2, and these entries were made at or near the time of the event. All these services performed by Ms. Riemann and Ms. Mahaki were done under my direction, supervision, and control. And I can state in my place that this is the time spent by the firm in the pertinent period for the offer of settlement for attorney's fees and expenses. We're asking the court to award I don't know why I don't have the total handy.
Well, on the first one of these that you passed up, the total is $9,041.67.
Right, and added to that would be $602.64 for the legal assistant.
So those two added together is the total you're requesting?
It is, Your Honor. And I'll just mention the court had asked the parties to mediate this issue prior to a hearing, which we did to an impasse. I just want to make you aware of that as well. That's all I have.
Okay, so the total you're requesting is 9,644.31.
Correct.
This was styled as a motion to amend. This is styled as a motion to amend the verdict.
Yeah, I think this is my first such motion. I don't know why I entitled it that. Your
Okay.
law clerk we had some correspondence about that, but motions, no matter what they're styled or titled, need to be construed on the merits. And looking at it, it's clearly a motion for attorney's fees under 9/11/68.
It is. I just wanted all of us to say that out loud while we're all in the same space to go, that's my intention. Just want to make sure I'm not missing it. And I don't remember seeing any objection to the award from the defense. Did y'all file any sort of?
Your Honor, I don't believe so. I mean, once I got involved after the verdict, and I believe after all the motions were filed. What I was here to really discuss is that we had the court order of mediation in this matter. I believe it's back in January. Is that right?
That's about what my memory tells me it should have been. That's the best I can do.
It was my understanding that we had reached an agreement of $82.50 for his fees. And I think there were some other stipulations involved in that. At that point, I was removed from the case. A new attorney came in and we gave each other cases and that kind of thing. So I had no input in that matter once I was taken off the case. But it was my understanding that we had reached an agreement for $8,250 in his for his attorney's fees. I have now since technically been put back on the case, even though that apparently my entry of appearance has not been filed. Just basically found out about this hearing yesterday, called counsel, discussed it with him, and just here to, I thought we had reached agreement back in January. That was my understanding of that.
So normally, okay, so I'm going to pivot back
Okay.
over to here, Mr. Calderon. So Mr. Calderon, normally after mediation, y'all normally file, the plaintiff normally files some sort of certificate of mediation that says, even if it's under your own signature, that says we mediated and we resolved, or we mediated and we didn't. I think an email was sent. Okay, so we did get an email saying that there was no agreement reached, but there's nothing in the file. I'm just saying that out loud so y'all know what my viewpoint on this is. But I would like you to address whether or not there was an agreement on the 8250, or is there an agreement today on the 8250, or is that just
Judge,
incorrect?
I left the mediation thinking we had an agreement and that it would be paid within 10 days. It wasn't. And then according to the new lawyer who came in after Mr. Salmons, they had to get approval from the insurance company. It wasn't approved.
Okay, now that makes sense.
So, again, had they paid the money back in January, we wouldn't be here, but they didn't, and that's why we're here.
I'm catching that because you bowed out once the agreement was reached, is what I think I just heard.
I believe that's correct.
Yeah.
Your Honor.
So, okay.
But part of the agreement was that the funds be paid within a time certain, and they weren't. So
Right. And you have not received any check for 8250 or any amount.
I haven't received a check for the attorney's fees, for the judgment, nothing.
Nothing. Okay. Okay. All right. Mr. Sam, is anything else that you would like me to address from the defense side?
I don't think so, Your Honor.
Let me just see, I wanna look something up. All right, Mr. Calderon, do you have a proposed motion? I mean, proposed order?
I
Excuse
do.
me.
Let me see, I have, may I approach, Your Honor?
Yes, you may.
Okay.
Okay, Mr. Sammons, I found your entry. So you were substituted in on October 10th of 23.
Okay.
So I found where you came in. I was trying to frankly save you filing in all honesty, I was just trying to save you filing another entry.
I understand.
I thought if I could. No, I don't ever have you filing back in, so.
Okay.
Oh yeah, you're just gonna need to just file a simple entry, that'll do it. Okay, that's all I have. Okay, then I have everything I need. I have the argument, I understand how we got here. And if you will, I may want to modify a little bit of the language in here to address kind of how we got here. So if you'll email a Word copy of this, or do you just want to? Yeah, if you'll just email a Word copy to Mr. Hope. or have your staff do it?
I'm a dinosaur. I work in WordPerfect. I can convert it, but
No, you can, yeah, we can convert.
it doesn't convert very well, is what I'll say.
A PDF is just as fine. I mean, however you want to
Okay.
send it, we'll figure it out. So we're pretty technologically comfortable here.
All right,
So-
I'll send it both in WordPerfect and Word, but the Word is, when it's converted, it's hard. I find it easier just to recreate the document.
Well, when I was a kid, my parents' second career was being an attorney. My dad was a pilot. When Eastern went out of business, he became an attorney. And anyway, he always used WordPerfect. So he spent his whole career, moving all of his forms from WordPerfect to Word. So I just want you to know, I'm the one who had to do that. So very comfortable with that process.
Quite frankly, I still say it's a far superior product. I don't know why anybody uses Word, other than it's free.
I remember liking WordPerfect a lot more than Word, but Word is what rules the world. So Microsoft's got it. I think they said they've got like 70% of all productivity computers run Windows and Office. So I was like, well, you can't really do much with that. So,
Right.
all right. Well, y'all, thank you very much. Have a safe
Thank
drive
you.
back. You'll get an order in your email sometime very soon.
I'll call my office right now and get them to file
That would be great. So, and again, you're there. I see you.
it. I just need to be back there.
You just need to be back there. So.
Thank you, Your Honor.
You checked out of the hotel, you got to check back in. There's a song about that from the 70s. Okay, that takes care of Nobles. Let's do the other shorter case. So I'm going to jump down to 23 SO 202, which is Hurt versus Briggs. So plaintiff over here by the jury box, defense over there. Y'all do want this taken down. Thank you, Kathy. Give me a minute to close one and grab the other. So my Adobe has disappeared from my printer. Can you try to print something and see if Adobe is on your printer option? I'm just trying to print a Word document to Adobe, and I tried to do it this morning on that one, and there was no Adobe. And now I'm opening up this one. There's no Adobe. So when you hit print, come up with, yeah, that's what I got it. Technology. Okay, then I've done something wrong. That's never happened. We'll come back to it. All right. Ready, Kathy?
Yes, sir.
Okay, so we're now going to pivot over to 23 SV 202. Let's just start with, since we are on record with the attorneys announcing their names, that way we have a good clean record of who's here and what are they saying.
Good morning, Your Honor. Vivian Uchitel for the plaintiff. This is defendant's motion to set aside.
Okay.
Cullen Mason here for the defendant. This is our motion to set aside.
All right, so I've got everything lined up on my end. The floor is yours. You're welcome to sit or stand, however you prefer. I don't have a jury here, so as long as you follow the basic courtroom procedure, you're good to go. So,
Excellent. Your Honor, at the outset, so long as the court is amenable, I'd like to reserve a right of rebuttal.
sure.
Thank you, Your Honor. I don't know if I really need this. Your Honor, this is our motion to set aside on an underlying default judgment. Just as a brief recitation of facts, I'm going to try to keep this whole thing as brief as possible, so I'm not just regurgitating a brief for you. On June 15th, 2023, on or about, the plaintiff filed the underlying lawsuit. I believe best of my recollection, it was a simple breach of contract, money damages type lawsuit. They didn't attempt to serve this until over a month later on July 17th of 23. That service was not received by my client. They attempted only to serve the registered agent of our entity client. Then just 8 days after that attempted service, they went straight to substituted service via the Georgia Secretary of State. Your Honor, it's our position, and just in broad strokes, I think the big things in our motion are simply that the plaintiff's counsel did not exercise correct levels of diligence in attempting to serve us. We did not receive the service through no neglect, mistake, or anything of our own, but purely through mistake or neglect on part of the plaintiff. And also, Your Honor, the fact that, excuse me, there were just so many alternatives to service that statute mandates before skipping over to substituted service through the Georgia Secretary of State, mixed in, of course, with the fact that there's strong reason to believe in this case, Your Honor, that plaintiff didn't keep the records appropriately. We have the underlying project here was in Baton Rouge, Louisiana, on a property that's known as Lily Bayou. Our client was never in contractual privity with the plaintiff. What the plaintiffs have offered is a credit application that I have a sworn averment from my client, Mr. Terry Briggs, the owner of Briggs, Georgia, saying he never signed. No one there ever signed. It doesn't match up with his handwriting. What they did have was $17,000 worth on or about $17,078 worth of equipment rentals from Herc Rentals that didn't work from day one. Herc Rentals assured us multiple times, had people go out there to review the equipment saying, yeah, it's broken, we'll do something about it. They never did. So a 3-month project for $17,000 turned into an 8-month project where we had to take on all the costs of remediating, replacing the defunct equipment that never worked. And then all of a sudden, with no knowledge that any of this lawsuit is going on against Briggs, Georgia, he calls us saying that, meaning my client calls us, Mr. Briggs, saying his account is frozen because he's being garnished and he has no idea why. And Your Honor, going back and just going through these one at a time, first of all, the diligence, I think the facts speak for themselves. Statute mandates under Georgia law, Your Honor, that, and far be it from me to tell you, that only serving the registered agent of the corporation, giving it about a week, and then immediately skipping to the absolute last resort of service through substituted service is totally improper. It is a total skip over and corner cut on notice, which is the bedrock foundation of due process, not only in the state, but in the country. They had 3, I think the Georgia Secretary of State's website has 3 listed at the time, and to this day, officers of the corporation that they could have served. And moreover, Your Honor, statute offers the possibility of serving through the secretary of the entity at their principal address, which again was listed publicly on the Georgia Secretary of State. Proper address has been there since they started business. So not only was that service premature, Your Honor, but there was no, or the Secretary of State service, I mean, was premature, but there was no due diligence done to effectuate that substituted service, to cross that threshold bar under statute, to then make substituted service not only a viable avenue, but a preferable one. And this is a mandate, Your Honor, to go into, and this is OCGA 911-4E1, to attempt substituted service properly, having checked all the boxes, so to speak, you have to try to serve everybody at the corporation. It's just standard procedure. The officers, the secretary, the statute gives so many alternatives for perfecting service on a corporate defendant because of situations like this, of situations where you skip to substituted service, all of a sudden we have a default that the defendant knows nothing about, then we're here wasting the court's time instead of trying a case on the merits, which under Georgia law, default judgments, and again, far be it from me to tell Your Honor, are the absolute last resort when a defendant is clearly, essentially, and we've all seen this, running from liability because running from liability because they know they're liable and they're trying to kick the can down the road on collections. That is not the case here, Your Honor. Mr. Briggs not only was not in contractual privity with the plaintiffs on the underlying lawsuit, the plaintiffs themselves have records indicating that on the bond, Briggs, Pennsylvania was the prime contractor that they were in a contractual relationship with. Then on other documents, they have Briggs, Texas listed as the contractor they were in privity with. Then with Briggs, Georgia, they have an invoice for the rental and then a credit application that we never even signed. And I have an affidavit and a veriment from my client. The handwriting doesn't match up. If the court would like, we would be happy to supplement the court with a handwriting expert's report definitively showing that as not only not Mr. Briggs's handwriting, but that he never signed or even saw that document.
Okay.
Your Honor, and this is just a couple of other points that I think are appropriate to point out here. I know we're not here on the merits of the underlying action necessarily, but I do think it's important to point out for due process reasons that, as I mentioned before, typically with these default cases, what you're going to see is a defendant willfully ignoring a lawsuit or dodging service in order to kick the can down the road because they know that the plaintiff has a strong case against them. In this case, Your Honor, as I stated in my recitation of the facts, not only does plaintiff have an exceedingly weak case against Briggs, Georgia, if anything, has a strong counterclaim and claim for attorney's fees against Herc Reynolds because they breached the contract from day one with Briggs, Georgia on that $17,000 equipment rental only, not the wider Lily Bayou project, which whether contractual privity rests with Briggs, Texas, Briggs, Pennsylvania, the plaintiff doesn't even know, Your Honor, which is why now we have this credit app that we never signed, subject to as the underlying subject of the default judgment, in a way to attach Briggs, Georgia, who is a separate legal entity from Briggs, Texas, from Briggs, PA, and therefore is not liable under that general contract. Your Honor, further, and I think this is just an important fact to point out, not only do we have meritorious defenses and a strong counterclaim, I would contend, Mr. Briggs is also not some bumbling pro se litigant. He is a sophisticated corporate litigant who has retained us as counsel for about 5 years now. Over those 5 years, Your Honor, every single time there's even a twitch of the hair on an issue, he is calling us, emailing us, anything. The fact that we didn't hear anything about this until, the gooses run the gambit and his accounts are frozen and we have a garnishment on a default judgment we've never heard anything about, that speaks volumes, Your Honor, to the fact that we never received service. And I do, again, far be it from me to remind the court on basic service procedure, but I do want to reiterate here that, and I've had motions like this before being on the other side of, just to say I'm familiar with the rule of law on service by mail especially. Mail service is good service unless, and this is axiomatic, but unless it can be refuted. And when we have an affidavit saying not only did Mr. Briggs, as one of the agents and officers of this company, never receive anything, service was never attempted on him, it was never attempted on the CFO, the CDO, the president, the owner as Mr. Briggs, anybody, except one time with the registered agent. And then a week later, we throw our hands up as the plaintiff and say, oh, well, we tried. Time to skip all the way to the end of substituted service. We have his affidavit in conjunction with the simple common sense fact that he's a small business owner. He hasn't done anything wrong here. As soon as there was a breath, the thought of a lawsuit carrying on, wafting through the air, he would have immediately offered up a full answer, a full defense, and a full counterclaim if he had received anything and known about any of this. And I think that strong circumstantial evidence mixed with the affidavit, Your Honor, carries us over that burden. I think this goes from more what so many of these cases are, where an attorney, for instance, forgets to send RFA responses and wants to contest service on them. Instead of a mere conclusory statement from an attorney in a case like that, what we have is not only a situation where we have our affidavit, we have a credit app, we're completely contesting the veracity and truthfulness and legitimacy of. We also have the strong circumstantial evidence, both of our multitudinous and viable defenses and counterclaims under this contract, under the frankly incredulous facts and overt facts that are presented by it. And also the simple fact that Mr. Briggs is a small business owner who takes these things very seriously. My firm has known this for 5 years. Like I said, he's so diligent as a client, it's almost irritating. And so to have him either ignore service or not respond to it or not let us know is so abnormal as to be burgeoning on impossible. So I think that really covers the whole case, Your Honor, and I trust that you and your staff attorney have reviewed these documents and everything else. I think that about covers all the biggest issues in this case, Your Honor. It really just comes down to a lack of diligent service, or a lack of diligence in pursuing service, I should say, a lack of receipt of service, the fact that we can prove lack of receipt of service and refute it pursuant to law, the fact that the plaintiff can offer no proof that they served any of the other officers besides the registered agent. No officer of the corporation, not the secretary of the corporation, of the principal office address, none of it. Georgia law requires perfect diligence before service is substituted. And I can tell you from experience, Your Honor, if this was an individual, I've had service by publication on an individual, which is about the closest analog to service by the Secretary of State for an individual versus an entity, get turned away and rejected on far stronger showings of diligence than this. Then one mail out, and then a week later throwing our hands up and saying, well, we tried. And again, Your Honor, I just want to lean on those defenses, the underlying facts. This is just something that due process and substantial justice demand, not only in this state, but in this country. We have a trial on the merits. And I think that's our principal position right there, Your Honor. And of course, I'll reserve my right to rebuttal after we hear from my co-counsel on this.
All right, thank you.
Thank you.
And spell your last name for me one more time.
Mason, M-A-S-O-N. Yes. Poem like the vampire, Mason like a stonemason.
All right, got it. Thank you.
Thank you, Your Honor.
All right,
Thank you.
floor is yours.
Your Honor, you know what they always say, there are three sides to every story. My name is Vivian Uchitel, and I represent the plaintiff, Herc Reynolds, in this matter. Herc is an equipment rental company with branches all over the United States and Canada. Herc rents equipment and tools to construction and industrial businesses, small and large. And when a customer account is placed for collections, it is placed in the state where the customer represents and maintains its state of incorporation or its principal place of business. Now, in July of 2021, Briggs Brothers Enterprises Corporation submitted a credit application to establish an account with Herc. That credit application lists its state of incorporation as Georgia and the physical address at 12 Doran Court, Smyrna, Georgia 30080. While Mr. Briggs' signature is not legible on the copies attached to Briggs' motion, Mr. Briggs' signature does appear on the copy attached to the complaint and on the original maintained by the branch. And I have a copy of the complaint right here. It's extremely faint at the bottom, but it says Terry Briggs, and if you cross-reference this with the affidavit signature, you can see that they're the same. And also, Mr. Briggs also executed rental agreements with Herc to rent the equipment from Herc with an estimated start date of July 30th, 2021. The rental agreement signed by a Briggs rep also lists a billing address of 12 Doran Court, Smyrna, Georgia 30080. There's no mention of any other state of incorporation for Briggs on any of these documents. Now, per the rental agreements, the rented equipment was to be billed to the Smyrna address, and the rented equipment was supposed to be shipped to Baton Rouge, Louisiana. The credit application and rental agreements are attached to the affidavit of Amber Ackerman, which was filed in opposition to this motion. Briggs subsequently failed to pay for the rental equipment in the principal amount of $148,827.09. This case was placed for collection with my firm because the credit application lists Briggs' state of incorporation in Georgia, and the rental agreements list the invoices with the billing address of 12 Doran Court in Smyrna. Briggs is in fact a registered entity in the state of Georgia. Again, there was absolutely no indication of any other state of incorporation on the supporting documents my firm received when the matter was placed with my firm. On June 15, 2023, Herc filed this matter in this court as the Georgia Secretary of State's online records list Spalding County address is at 413 Odell Industrial, Griffin, Spalding County, Georgia as the registered office address, and Terry Briggs is listed as the registered agent. And I want to point out, Mr. Mason talked about, well, they didn't try to serve anybody else, officer of the corporation. Well, Terry Briggs is the registered agent, he is the CEO, and he is the secretary of the company. On July 17, 2023, the Spalding County Sheriff's Department attempted service on Mr. Briggs at 413 Odell Industrial. Now, from the entry of service form, it doesn't say how many attempts were made. The sheriff's deputies just put on there that he could not make contact with Mr. Briggs, and he returned the non-S to my office. Herc then caused Briggs to be served in accordance with OCGA section 14.2504B. Now, Mr. Mason said that we tried serving through the Secretary of State, and that's not correct. We served through 14.2504B. We sent a certified letter addressed to the corporate secretary, which is Mr. Briggs, at the principal office address listed at 12 Doring Court. The USPS tracking produced by Briggs with their motion indicates that someone either declined to sign for the certified mail or that no one was available to sign. The tracking also states that a notice of the certified letter was left at the principal office address with a reminder to reschedule delivery. It's unclear from the tracking if Briggs' representative ever rescheduled that delivery. Now, per 14.2504B3, service was perfected on August 9, 2023. Briggs did not file defensive pleadings, and plaintiffs submitted a motion for default judgment on September 26, 2023. The court entered judgment on November 15, 2023. Now, in October of 2023, after submitting the motion for default, but prior to the court entering judgment, my firm learned that there was a bond on this project in Louisiana. My firm submitted a proof of claim toward the bond, but our claim was denied on November 30th, 2023, because the project was completed on federal land, which required her to file a lawsuit in federal court within a year of completion of the rental equipment. Upon information and belief, Mr. Briggs was notified of this bond decision through an email on November 30th. After the bond claim was denied, Herc filed his bank garnishment, or a bank garnishment, and after the bank garnishment was filed, that's when Briggs filed the motion to set aside. Now, Herc maintains that service of process was proper in accordance with 14.2504B, and that this court has jurisdiction over Briggs to enter the judgment. 14.2504B provides, and I quote, if a corporation has no registered agent or the agent cannot with reasonable diligence be served, the corporation may be served by registered or certified mail or statutory overnight delivery, return receipt requested, addressed to the secretary of the corporation at its principal office. Herc is unaware of any cases that actually interpret reasonable diligence under this particular statute. Now, the Georgia Court of Appeals upheld the trial court's finding of reasonable diligence permitting substitute service of process despite the fact that only one service attempt was made. And I cite Vasil versus Addo, that's 341, Georgia App 236, a 2017 case, and also B&B Quick Lube.
No, you got ahead of me. So
Sorry.
341.
Georgia App 236. And then there's another one.
All right, I have it. I'm ready. What's the next
The
one?
next one is 283, Georgia App 299. And the latter one is a 2007 case.
I have them both.
Okay, and the B&B Quick Lube is the one I'd like to focus on. In that case, G&K filed suit against B&B and sent the summons and complaint to the Fulton County Sheriff's Department for service upon B&B's registered agent at the registered agent office address. The Fulton Sheriff could not serve B&B and determined that the building was empty. G&K then served B&B in accordance with 14.2504B via statutory overnight delivery. B&B did not answer, and G&K obtained a default judgment. A year later, B&B filed a motion to set aside, and the trial court denied the motion, and B&B appealed. B&B argued that G&K did not employ reasonable diligence because it had only attempted one service, and they also argued that the statutory overnight delivery violated its due process. The Court of Appeals found that there was some evidence from which the court could conclude G&K exercised reasonable diligence. The Court of Appeals further rejected arguments that service via statutory overnight delivery violated a company's right to due process finding that 142504B does not require the complaint to be received by the registered agent or corporate officer. Instead, the court reasoned that this statute explicitly contemplates the possibility that service may be deemed perfected even if there is no evidence that a corporation ever received the complaint. The court ultimately found that the trial court's denial of a motion is not an abuse of discretion, even where there's only one service attempt. And that's on page 302 of the opinion. Here, a Spalding County Sheriff's Deputy attempted service on Terry Briggs at its registered agent for service of process, but returned it stating no contact. The Georgia Secretary of State online records demonstrate that Herc attempted service at this proper address. There's no allegation that Herc attempted at a wrong address. Plaintiff then caused Briggs to be served in accordance with 142504B by sending the certified letter. The tracking information demonstrates that the post office attempted delivery, but that no authorized representative was available to sign. There is also something else in their brief. They're claiming mistake, but Mr. Mason did not argue that today. But they're saying that it's a mistake because they didn't receive the actual lawsuit, but that's not a mistake that's contemplated under 91160D2. Your Honor, it's undisputed that Herc followed the letter of the law with 142504B. We didn't try to serve under the Georgia Secretary of State. And with these grounds about challenging the proper entity, like I said, we have a signed credit application. If you look at the signatures, they are one and the same. After obtaining the judgment and once Briggs Counsel got involved, that's when my office learned about 4 separate corporations in 4 separate states that have the exact same name. We didn't know about this. We put an affidavit in stating that Herc thought at all times they were doing business with the Georgia entity. So in conclusion, we attempted service at the registered agent, on the registered agent, at the registered agent office address. When the sheriff was unable to make contact, we attempted service via 142504B. The tracking provides that the post office attempted to serve it or attempted to deliver it. And I want to point out again from the case, the B&B case, the denial of a motion to set aside is not an abuse of discretion where a plaintiff only attempts service once, as long as there is some evidence that reasonable diligence was exercised. Thank you, Your Honor.
Okay, thank you. Floor is yours.
Keep this quick, Your Honor. So first off, co-counsel mentioned the bond documents as well as some other documents. I mean, those bond documents, again, I'm just going to really lean on the fact here that under law, corporations are separate entities. So you got Briggs, Pennsylvania, you got Briggs, Texas, Briggs, Georgia. How Herc can say we thought we were only doing business with Briggs, Georgia, especially under this credit app, which we have an affidavit saying was never signed, and on equipment that didn't work, $17,000 worth, how we got to $140,000 is beyond me. But the fact that simple corporate formality needs to be respected. On the bond, Briggs, Pennsylvania is listed as the contracting entity. Briggs, Texas is listed in other documents, and then we have a credit application that is in dispute and some invoices for work that was done that is for a lesser dollar amount, and where Herc was in breach. None of that really adds up, Your Honor. And then in terms of diligence, Your Honor, it isn't just reasonable diligence, Your Honor. Reasonable is going to change on the circumstances. It's purely because of how the statute's written. You have to serve every possible listed officer before you can skip to the Secretary of State, skip to 142504B, whatever it is. Sure, Mr. Briggs is listed as multiple officers, employees, but he's not the only one. And even then, they only attempted to serve the registered agent. That is not proper under the statute. Beyond that, Your Honor, I'm just going to lean on our brief as it's been put forward. We still contest the handwriting, and I would be happy to have an expert come up to supplement the court on that to show that that is not Mr. Briggs' signature.
Okay. All right, I get it. And this was well briefed, by the way. So y'all did a good job lining this up for me to help me really wrap my brain around it ahead of time. So, okay, so I will be taking this under oath, but, we'll just say that, this one is a close call. I don't mind saying that at all. Normally, when we get the motions for default, it's just somebody saying, I really screwed up and I really, really don't want to have to face my client. So I just want to acknowledge that, this is one where we wanted a hearing because it is, both sides have valid points here. And so we're going to take these under advisement. The cases that y'all referred to and the statutes you've referred to in your arguments, of course, you brief them, but I'm also, whenever they come up in an argument, I always take note and take an extra look at them before I make my decision. So do you wish to, let me see. Do you wish to address anything else?
Your Honor, the only thing that I want to point out again is the point keeps being made that we didn't try to serve the secretary or the CEO. Again, these people are one and the same. I just want to make sure that that's clear. And also, with respect to reasonable diligence, again, there's not any case law out there that says, there's no case law that says we have to go through and tick and serve everyone before we resort to 142504B. It specifically says, all you have to do is show that you've exercised reasonable diligence. Now, what that is, that's up for the court to determine. But what the Court of Appeals has said is if the court can find any diligence, which we have, we attempted to serve them at the registered agent office address, that's sufficient to overcome an abuse of discretion.
No, I understand. And I did look up what the, as I always do, what the standard would be, and it is an abuse of discretion going up. So the ruling, if there's any evidence to support the ruling, then we're good to go. So, all right, anything else that you wish to address?
As one last thing, Your Honor, I would say that just generally with any kind of mailing service, it's just the law of Georgia that it's valid until we can prove it isn't. And I think based on the strong circumstances we have for our meritorious defenses, for our counterclaims, our affidavit from my client, even in the face of their opposing affidavit, even if they did mail these things, we didn't get them. This is a case that, again, has strong merits on an answer and counterclaim. And so I think to go into a default judgment on this is just sort of whisking over those counterclaims. And again, Your Honor, I want to point out, my co-counsel mentioned lack of mistake or mistake and then lack unmixed with the negligence of the responding party or moving party, I believe is the actual language. Your Honor, there's no mistake or negligence on our part. And even if you have multiple of the same guy under a corporation's listings on the Georgia Secretary of State Entity Search, you still, under law and by procedure and by formalities, have to serve them, simply by statute.
And I understand the positions each of y'all are taking on that. So I get it clearly. So, okay. Anything else? So I'm going to have you all submit proposed orders. Since there's a lot of moving parts here, I'd like to give us each something. What type of time frame do y'all need to get that to us? Don't rush it. Take the time you need. Let's just do 14 days then. So y'all take 14 days. Email that to Mr. Hope and myself. Word format. I'd say Word perfect, but we don't have Word perfect. So, and that's it. So y'all need anything else?
Your Honor, do you have a specific email address that you have?
I do. I mean, I'd love to be included. So my email address is just jthacker@Spalding County. We're all our first initial and our last name at Spalding County. So Kathy's is, cleach@spaldingcounty.com.
Okay.
And Alexander Hope's is A-Hope, and Hannah Arnett, judicial assistant, is H. Arnett. So,
Okay.
Is that with two T's, Your Honor?
yes. So that's at least the good thing is that everybody's pretty predictable. So, okay. Thank you all. So I'm going to put a note that proposed orders will get here in 14 days. And then we'll go from there.
All right, thank you, Your Honor. Maybe
Thanks,
you can
y'all.
excuse-
Have a safe drive back.
Thank you.
Okay, I'm going to take a very quick restroom break. While in the meantime, Alford and Walden, y'all come on up to your spots. So plaintiff by the jury box and defense over farther. And then whoever needs to talk to Kathy, y'all chat with Kathy. Okay. Oh, that's right. Okay, so help me again with the takedown.
I would like it as it relates to the arguments on the motion for summary judgment.
Okay, you want to split on that?
Well, technically, they would be splitting it, so I don't think they want
Okay,
any part of that.
all right, well then it's yours. So, is that correct, y'all?
You don't want to pay for a transcript for the
No.
motion hearing, do
Okay.
you?
All right, well then let's just do this. Since we are a little bit on the record, let's just have everybody put their names across. That way I've at least got names attached with voices on the record. So we'll just start here and come across.
Jimmy Rice on behalf of Tim Alford.
Robert Mills on behalf of Tim Alford as the counterclaim defendant.
All right, thank you, Mr. Mills.
John Caldwell for the defendants, Larry Walden, and JMF Towing and Recovery LLC as the named defendants in the case in chief.
Okay. All right, and then you're Mr. Walden?
I'm Larry Waller.
All right, and what's your name, sir?
James Orf,
James Fort?
Fortner,
Fortner.
yes.
And so for record purposes for them, they would be the pro se litigants in the counterclaim that they currently have standing against Mr. Alford, the plaintiff in our case in chief.
Yes. I remember us doing this last time and going, I might need a chart with some pins and strings. So the counterclaims always work out this way. All right, so Mr. Fortner, just a quick question. So are you here as a witness? You here as, what's your role?
I'm the owner of the towing company.
Okay, JMF Towing and Recovery?
Yes, sir.
Eh. Is it incorporated or is it just
It's
a
incorporated.
okay. Well, y'all have an Eccles issue. So corporations can't represent themselves here.
Correct, Your Honor.
Dang it, that's exactly what I was trying to get lined up before we got here. So just to clarify my issue, in magistrate court, you can appear for cases as the owner, unless you're, without being an attorney. In the state court, there's a case called Eccles by some guy named Eccles, where they said no corporation can appear without an attorney because you're not an attorney, but I know it's your company and it's your heart and your soul, but by speaking, you're speaking on behalf of a separate incorporated entity, which means you're representing somebody in court, somebody being a corporation. Does that make sense?
Yes.
And so my issue here is that you can't do that. I can't even let you do it. Like I can't let them waive it. It's nothing I can do. So, I'm very sorry. I was hoping to get that all lined up before we got here, but that is not lined up.
And Your Honor, if I might interject, we've discussed him getting a private attorney for this case. He has, to his benefit and credit, consulted with private attorneys. Unfortunately, none have agreed to accept the case yet.
Yes.
So he has tried on that end, but I guess you can't force other attorneys to take a case they don't want.
No.
That's the issue.
So let me make certain I've got each person's role here to make certain I've got this absolutely correct. So Mr. Rice is here representing Mr. Alford, and I'm just going to call the mothership, the main case.
Yes, sir.
And you are here, Mr. Caldwell, representing both of them in the main case.
Correct.
All right, so we've got that part clear. As defendants, as counterclaim defendants, they each have a case that they filed. In this case, they have added a section that's a counterclaim against Mr. Alford. Mr. Mills, you are here, I guess, as the counterclaim defense attorney. So you're defending Mr. Alford in the counterclaim.
Correct.
But Mr. Caldwell, you are not representing them as the counterclaim plaintiff's attorney, correct?
That's correct. So when this case initially came in and we were retained to represent Mr. Walden and JMF Towing and Recovery LLC, when the answer was pled, a counterclaim on their behalf to preserve the counterclaim was pled for them in consultation with them, after which time our retaining company, if you will, which would be our insurance carrier, of course, established and advised the parameters of the representation, which would not include the prosecution, if you will, of the counterclaim against Mr. Walden. And so we have spent much time discussing the counterclaim and the need for Mr. Walden individually and JMF Towing and Recovery as a company to retain private counsel to continue the counterclaim. And again, back to my initial statement, they have attempted to do so, but have not had success at the moment of finding private counsel.
Okay. All right. Well,
And we did also, for the record, file a motion to withdraw for the purposes of establishing in the record that we officially and legally did not represent Mr. Walden and JMF Towing and Recovery LLC in their counterclaim.
which is what I asked you to do last time. So y'all have done what I need you to do. The only step that didn't make it, and it sounds to me like due diligence was used. It sounds to me, I just want you to hear me say, Ms. Fortner, that I'm hearing that you did what you tried to do it. You tried to get an attorney to come to court and no one would take your case. So, all right, well, I'm going to move forward. I said last time that we are moving forward with this hearing one way or the other, the next hearing, because I'm not confident that additional time would find an attorney. But Mr. Fortner, I just need you to know I'm going to have to step very carefully around you. I will give you any voice that the law allows me to give you. Does that make sense?
Yes.
But I will not step past that. So just move with me carefully as we have this hearing, because I can't let you say a whole lot. And you'll have to wear a couple of different hats as we go. So.
And I have also, again, Your Honor, spoken to Mr. Fortner for the purposes of this hearing. He could be a witness in order to argue the merits of the counterclaim that JMF Towing and Recovery has. And so he understands that and is prepared to do that to the extent it needs to be done.
And that's exactly what I had in mind, is I could give him some voice here in an appropriate capacity that we would all agree the title of before he opened his mouth. So, okay, well, that's what we're going to do. Okay, so let's, I knew we had a lot of housekeeping to sort out, but it sounds to me like we're all on the same page as where we're at. We are moving forward. I'm going to open up your file here, and we're going to get started. So we have the counterclaim. We're here specifically on the motion for summary judgment, and that's Mr. Mills. That's what we're here on record for specifically. So let's go ahead and do that part first. And so any other housekeeping from either the plaintiff or counterclaim defendant before we get started? Mr. Rice first.
Just briefly, Your Honor, we, pursuant to the court's order, Mr. Caldwell and I both filed motions in limine on behalf of the respective parties regarding really the bodily injury part of this case. But I just didn't know while they were arguing that I was going to look over his, or whether the court was inclined to hear those another time. And I mentioned that only because Mr. Caldwell's, on behalf of the defendants, has put forth two experts that were deposing, one a medical bills expert and the second is a orthopedic surgeon regarding the injuries that I'm going to be deposing. And I anticipate, I don't want to say the court hates him, but I anticipate a dollar motion regarding the medical bills expert that's going to probably extenuate or elongate the case, whatever the proper word is, make this go past where we are. I'm happy to argue all these before the court today, but I don't know if the court prefers it all be done at one time.
No, my main motion today, my main goal, because if I can sort out the motion for summary judgment, that gives you all a much clearer platform or landscape or whatever you want to say for y'all to know what's going on next and the attorneys to know what the next strategic steps are for them. So, no, I'm thinking we should break it up. Okay. Yeah, I'm with you. All right. So floor's yours. All right. Any other housekeeping?
That's all, Your Honor. Obviously, I'm not representing Mr. Walden, and to the extent Mr. Fortner that he's here for today, but I will attempt to assist them in moving along
You may speak quietly to them as we go. How
this
about that?
motion.
In a non-representative but slightly, knowledgeable way.
Thank you, Your Honor.
Okay. Ms. Mills, floor's yours.
Thank you, Your Honor. Largely, to be honest, I will rely on the brief that was submitted, and everything that was said from a procedural and timeline standpoint thus far is generally correct. But to take that one step further, I think it's important to note. So both defendants, Mr. Walden and JMF, the corporation, filed their answers on the counterclaims back in April of 2022. They were represented by counsel up through whenever the withdrawal motion was filed, which I believe off the top of my head was this May. That includes being represented by Mr. Caldwell on both the depositions, which occurred in October of last year, including objections to various questions on my side of things, including the counterclaim. So for all intents and purposes, my position is they did have counsel up through basically a couple of months ago after the first hearing. And I think that's important to note, one, because after we filed our motion for summary judgment, no response or objection has ever been filed, including throughout that basically at least 6, if not almost 9 months after their sworn deposition testimony was taken until that motion was filed. Your Honor, substantively, in terms of the counterclaims, Mr. Walden clearly testified that he was not even aware a counterclaim was filed on his behalf. He also specifically contradicted several of the allegations that were included in the counterclaim. And taking that one step further as well, he specifically testified that he was not pursuing any claims for Mr. Alford, nor did he want him to pay any money related to the counterclaim. And again, the risk of just reading through the brief, I believe this falls under the prophecy rule in terms of precedent for situations like this that does not allow vague, indefinite, or self-serving affidavits. I will admit that that case speaks to when an affidavit is filed specifically for summary judgment purposes. However, I think it's analogous here in terms of allegations being put in a counterclaim that is unverified. Sworn testimony is then that they were not aware of it and do not wish to pursue it. And that is really the only record evidence that he's not trying to pursue it, and therefore the claim should fail in and of itself. The second aspect of this, leaving aside the fact that certainly as it relates to Mr. Walden at least, was not attempting to pursue the counterclaim, is neither defendant has offered any evidence to support damages. The counterclaim sounds negligence, of which of course damages are an essential element, and specifically special damages, which are included in both counterclaims, have to be specifically pled under OCGA 911 9G, and under OCGA 512 2B, when items of special damages are claimed, they shall be specifically stated. That has not occurred from either defendant in this case. Both on deposition and in written discovery, it is clear that neither defendant has any evidence they can put in front of a jury to create an issue of fact as to what their alleged damages are. Mr. Walden testified that he had no medical bills, and again reiterated that he was not seeking those to be paid. And the 30B6 representative of JMF Towing admitted that while the counterclaim requested repair bills and other special damages for property damage, he did not have the truck repaired, so there are no repair bills. He could not otherwise quantify any level of damages one way or the other as it relates to property damage. And therefore, even if either defendant is able to otherwise survive summary judgment as a whole, at the very least, we would be asking for, I guess, essentially a partial summary judgment order limiting their damages to a nominal amount because they cannot otherwise prove those damages. And again, just to wrap up, I'm sure you know the summary judgment standards, but once the movement, in this case, Mr. Alford as the counterclaim defendant has discharged the burden of showing there's no issue of material facts. The non-movements cannot rest on the pleadings in terms of they have to point to specific evidence to survive a motion, and they cannot do that because none has been provided despite requests for the same.
Okay, thank you, Mr. Mills. Okay, so, Mr. Walden, just so you know what's happening now. So they're asking me, Mr. Mills is asking me to dismiss what's called your counterclaim. If I agree with Mr. Mills, what will happen is, let's just say I agree with both of you, or for both of your cases, your counterclaims. If I agree with Mr. Mills and I do what he wants me to do, then Mr. Mills will actually go away from the case altogether, right?
Yes, sir.
Okay, and then the case will go back to just being Mr. Alford being represented by Mr. Rice and you two being represented by Mr. Caldwell, with them as the plaintiff and y'all as the defense and nothing else. Does that make sense, Mr. Walden?
Yeah.
All right. And Mr. Fortner, although I'm not asking you to speak, and I just need to make certain you understand that. Do you understand that's what's going on? Yes? Okay, he's nodded his head yes. All right. And Mr. Fortner, what was your first name again?
James.
James. I thought that was right, but I had a moment when I wrote it down and wasn't sure. Okay. So, Mr. Walden, I know that was a technical argument, and I recognize that. And I'm sorry to put you on the spot, but you do have the right to respond if you want to. You don't have to. But Mr. Walden, I just wanted you to know if you wanted to tell me anything about why I shouldn't dismiss the counterclaim, this is your chance to do it. And if you have any other questions, I'm happy to answer those as well, Mr. Walden. I don't want you to feel like, the big judge backed you into a corner. I want you to feel like you understood what's going on. That's important to me.
Start off with everything about the counterclaim.
Lean into the mic and slow down. This lady right here, Miss Kathy Leach, she's recording our conversation, and it's important because it's here to protect you. So just be nice and slow and loud and use the mic, and we'll keep going.
Like I said, I didn't want the counterclaim. If you want to keep it and everything, I will defend myself.
Okay. I hear you, Mr. Walden.
All because he did not have any business snatching the wheel to the right and cause me the wreck.
Okay. So I'm with you on that. It's just arguments, not testimony. So, all right. I hear what you're saying, Mr. Walden. Is there anything else you want me to know while I think about Mr. Mills's request to dismiss the counterclaim? That's the claim where you're claiming against Mr. Alford.
Well, if he want to keep the suit, like I said, he wasn't the one that was hurt. He wasn't the one in the hospital for 10 days.
Hospital for 10 days?
Yeah.
Okay.
I mean 7 days. When the wreck happened December 3rd, I went out from the 3rd to the 10th. He wasn't. He wasn't the one that got hurt. I was.
Okay. All right. All right. So, anything else you want me to know, Mr. Walden? As far as that question? Yeah, talk to your attorney. Okay.
Are you ready?
Yes, sir. Anything else you want me to know?
Well, like I said, he was arguing, picking on me in the truck, then leaned over, laid the truck over.
Okay, Lena.
They throw me out of the.
Hold on, I didn't catch that. And your attorney reacted, so that means y'all need to talk again before you say whatever it is I didn't understand.
offer testimony.
You want to offer testimony? All right. You understand if you offer testimony, Mr. Rice and Mr. Mills will be both given a chance to ask you questions. And you may be required to answer those questions even if you don't like it. Do you understand that?
Yeah.
Okay. Raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yeah.
All right, take your hand down. Normally, you would come up here to the witness stand, but I like where we're all at, so we're just going to stay tight. You use that microphone so it's good and loud and everybody can hear you, nice and slow. And again, remember, this is a very narrow question. This is not trying the case. All I'm trying to decide is there enough information here for me to keep the counterclaim open, or should I dismiss the counterclaim? Do you understand that's the only question on the table right now? Yes?
Yeah.
Okay. All right. Tell me what you want me to know.
He shouldn't have started off with. He was told not to go. He jumped in the truck. I left. And he was picking on me the way I talk, everything that I told him quit. Then he turned around and said, something like that, right before we had the wreck, he said, we been to wreck the truck and laid over and jerked the wheel to the right. And I tried to straighten it up and all, and it started flipping. Throw me out of the truck, broke my back through T1 to T5, broke 3 ribs, cracked 2, and peeled my head back from right here all the way back.
And that's the scar I'm seeing on your forehead? Okay. And you've already testified before you were placed under oath that you were out of work for 7 days. Is that correct?
I went to hospital for 7 days.
Hospital for 7 days. That's what I was asking. Okay.
Now, I was flighted from there, from the wreck to Macon.
All right. Thank you, Mr. Walden. Anything else before I let them ask you some questions?
No, not right now.
All right. All right. So obviously you might get excited about cross-examining him, but just remember the narrow focus of this. Mr. Mills, you may ask your questions.
Mr. Walden, do you recall your deposition in October of last year?
Not too much of it.
Do you agree with me that during that deposition, you offered sworn testimony that you were not pursuing your counterclaim against Mr. Walden?
Well, if they want to keep that going, I will pursue.
Was your sworn testimony that you did not want to pursue your counterclaim?
Back then, I did not do it. Did not want to do it. So he ain't got no money, and he won't get no money.
Is your testimony today that you are trying to pursue the counterclaim?
Clint, we give him some tissues. Clint, we give him some tissues. Take a deep breath, Mr. Walden. Mr. Walden. All right, let's do this. Let's just take a quick break. Let them speak off record. So let's just take 5 minutes, talk to your client, see if you can help him get focused. Right before I take it off record, do I have a copy of those transcripts? Piper, I think he's yours. I think he needs help. All right, so let's go back on record. So Mr. Walden had a medical episode, has been removed by EMS. It appears that it was something significant. So he was right in the middle of his testimony, his cross-examination. So I have no choice at this point but to continue this matter and to finish this up. So what we'll do is y'all stick around just a minute. Let's see if we can go ahead and pick a date beforehand so we can all have that date written down. Otherwise, we have to mail y'all something. Let's see. All right, y'all grab your calendars. Well, the next one will be September. Y'all start looking at September. 20? Yeah. About September 20th. That'll give him, I mean, whatever it is he has, I don't want him to feel rushed back. But I think that, that's a good 6 weeks, 7 weeks out. So,
That's
okay.
good. Thank you.
All right, so you're not going to get a new Rule 9 and I'll just see everybody back here for Part B of this. Hopefully, Mr. Walden will make a full recovery, and I'll see y'all back here on. So Debbie, if you'll just put this case back on for September 20th at 9 a.m. All right. Again, if y'all have, I might just be looking over the transcripts, but if you have any PDFs of any transcripts that even remotely might be interesting to me, file them and I will read them. So transcripts are always very helpful to me in making my decisions. So
For clarity purposes, on that 20th date, will it just be the motion for summary judgment hearing, or do we want to go ahead and hear the motions in limine and any other motions that have been filed?
I'm hesitant to do the motions in limine until y'all have done a little bit more of what you're doing. So let's just finish this one up. So, and Mr. Fortner, you can continue seeking an attorney. I guess that's a unexpected something that I just want to make sure you understand that just because you didn't have one here today, I just want to make sure you hear me say you're not prohibited from continuing that search.
Yes,
So, okay. All right, and then, again, my prayers are, and all of our prayers we were talking about are with Mr. Walden. Obviously, that is a horrific way to deal with it. Courts are stressful. I try very hard to run a court that's the appropriate amount of stressful. But obviously, I hope that he is okay, and I hope he makes a full recovery. Because y'all are good friends, right, I guess? Yeah, so please tell him when you see him that the whole team is praying for him. So, okay, y'all need anything else?
No, sir.
Thank you,
Okay.
Judge, I appreciate that.
Yeah, good job, y'all, getting this very difficult case lined up as best you can.
Thank you.
Thank you.
All right, my appropriate attorneys, y'all, since there's not that many of you, you're welcome to come up here and sit wherever you want, if you'd like to. And although these are normally plaintiff over here and defense over there, you're all defense, so, I'm sorry, you're all plaintiff, so you can sit wherever you want. There's an attorney who is now retired, and he always made it a habit of intentionally sitting at the wrong table to see if anybody paid attention, so. All right. All right, well, obviously, we ended up with everything else a little later than intended. I apologize for that. I hope I gave you all enough time to clean up any loose ends that you had before we called it, so maybe that'll work out for you, so. All right, so what I'm gonna do is just call the calendar. As you reach yours, you're welcome to stand if you want. You do not have to stand. You can address from wherever you're most comfortable, so. All right, here we go. The first case on the default no service calendar is 21 SV 347. Credit Union Loan versus Cheney. All right, that one has a bankruptcy stay. Okay, all right, so that one has a bankruptcy stay. I'm gonna ask the clerk to administratively close that one. And so I'm gonna put administratively closed. Okay, 22 SB 302, Credit Union versus Lewis. That one is still open. It's a no service. There's no service in the file. All right, that case is dismissed for lack of prosecution. All right, 22 SV 316 LVNV funding versus Pryor. One of these days I'll get to one of y'all's cases. That case is a default. Defendant was served on 12/13/22, and there's no additional action from the plaintiff's attorney. I'm dismissing that case for lack of prosecution. All right, 22 SV 350. Nicholas Financial versus Watkins. The last thing filed was a motion for continuance. None of y'all are here on that? Okay. The attorney filed a motion for continuance. Needs more time for service. Yeah, they're not here. So, okay, nobody's here. Couple of non-S in the file. This thing's been going on since 2022, so I'm dismissing this case for lack of prosecution. They're welcome to refile. All right, next case, 23 SV 16. American Express versus Milner.
Calling right for the plaintiff,
All right, let's see where we're at on this.
requesting additional time for service.
There's a oh, okay. It says the issue here is that there's two Chester Milners here in Griffin. According to the sheriff's notes on the service, on the non-est, excuse me. So when we stack these up, we don't normally move them to secondary calendars, but what I do make sure is, I just need to make certain that if this it has not been dismissed and refiled. That's always a key concern of mine. Because obviously, if in my mind, just to talk this through, because we'll have the same conversation several times, is if I dismiss it and you refile, that gives you 6 months to refile, plus an additional year to get service before I put it on the next default no service, versus if I continue it, I'm only going to give you a couple months. So I'm just letting you know, like, our habits and processes is that your better bet with me, even though you have a filing fee attached to it, is for me to dismiss it, as long as it hasn't been dismissed before. That's what I really need to know. So do you know if it's been dismissed and refiled?
I have no idea, Your Honor.
Okay,
So,
I do not see it previously. So if it was filed, it was filed somewhere else. Let me look one more place for it. Is Chester Milner, which, again, there's a couple of there's 2 Chester Milners according to the sheriff's deputy. What? That's what I figured. So that's why I was saying I didn't see it. So, yeah, I don't see any other American Expresses versus Chester Milner. So, all right, well, I'm going to dismiss it. That gives you 6 months to file. And then once you filed it, that gives you, an additional rotation of the sun to find him, to find the right one. And so I am going to dismiss it for lack of prosecution, but I hope you'll file it back with us, and we'll give you plenty of space to try again. We also have a couple of standing process servers here, and we're still working on that. That's a huge process that you need a court administrator for. And also, of course, you can always find your own process server if you need. So we approve those a lot. All right, 23 SV 18 Midland versus Waterford. Anybody here on that one? Let's see. Last action was service, I believe. Yeah, there's no default, nothing. So I'm always surprised by those. Okay, well, there was service, so it's a default, and I'm dismissing it for lack of prosecution. All right, next case is 23 SV 24 Moran versus McGill. Mike Moran. That's interesting. Mike does a lot of defense work. Y'all know Mike Moran? He's an attorney out of Atlanta. He does a lot of defense work. But I've never seen his name on the plaintiff's side. Yeah, it's been served and everything. Yeah. Okay, we'll circle back to that then. Okay, 23 SV 27 Truist Bank versus Cody Cheney. It's open. There's a motion for continuance, several non-ests. All right, so it's a no service, and I'm dismissing it for lack of prosecution. All right, 23 SV 32 Adams versus Geiger.
Good morning, Your Honor. Attorney Bailey, Mr. Geiger is here.
Welcome back, Mr. Bailey. It's been a bit, so it's good to see
It's been a
you.
long time.
Yes.
Yeah, I didn't think you were gonna recognize me.
I recognized you, so, but it's good to see you, and it's good to have you back.
Good seeing you also. I'm here with Mr. Adams. The case was dismissed, and then we brought it back, refiled it. We did serve the defendant. He has failed to answer. I did file a motion for a default.
Excellent. That's exactly what I needed from you. So we're good to go? Okay, so we are all clear. Do we need damages hearing, or is this liquidated?
It's unliquidated, Your Honor. We'll have, most likely need a damage hearing, Your Honor.
Okay. One of your other options is you may also, if you wish, file a motion for summary judgment as to damages. You're certainly welcome to do that. Lots of attorneys do that with us, and then we'll wait the 30 days. The downside of that, of course, you have to serve the defendant. So your call either way, but I'm just letting you know that we'll set it, but if you want to do the motion for summary judgment before that, and the time passes and nobody responds and nobody asks for oral argument, I'll grant it from chambers and you're done.
Can I do both, Your Honor?
So you can do, that's what I'm saying. Whichever one hits first is the one that controls.
Yes, sir. I do have an order, if you like, if I can approach.
Yes, if you'll just come on up and hand it to Mr. Hope, and is that your only case? Do you have anything else?
That'll be it.
All right. It's great to see you.
Good seeing you, Your Honor.
I was
Your case is what I always tell everyone.
Yes.
A lot younger.
We were both a lot younger then.
When you came in, I just want you to know, that case was going on for a minute. You came in and cleaned it up.
Well, thank you.
Very professional.
I just remember y'all did a good job, and that case was a mess, and we got it done.
You got it.
So it was a team of adversaries. So, well, y'all are good to go. Your case is under control. You've done everything you need. And Mr. Bailey, it's always good to see you.
Pleasure.
Come back more often.
Certainly. Thank you, sir.
All right. Thank you. You have a good day. Okay. All right, 23 SV 39, Scopos versus Elder. Anybody here on that one? No. There it is. He just asked for a hearing. All right, couple of non-Ss in the file. No action since filing. So, all right, 23 SV 39 is a no service and no action, so I'm dismissing it for lack of prosecution. All right, next case, 23 SV 50. JP Morgan Chase versus Key.
Carla Key for the plaintiff in that case.
Okay. Let me grab your file real quick.
Okay.
Excellent. Okay, you've got your motion for default filed as of today,
Yeah.
before I called it. So talk about sliding into home base like you're supposed to. So, okay, well, this looks great then. You filed your motion for default. You have done everything I need you to do on that case.
Okay.
So you are good to go. So, so I'm going to put motion for default filed. Back on track. All right, 23 SV 65. Euro Investment versus Hoyt. Looks like a no service. None of y'all are here on that. Yeah, it's a no service. Nobody's here and there is no service. So I'm dismissing it for lack of prosecution. All right, 23 SV 66.
Carla Key for the plaintiff in that one.
Okay.
We should have filed a default judgment in that case as well.
Let's open that up. Perfect. That's exactly what I want to see when I open these on these mornings. So great job. So the motion for default is filed. And I'm going to mark the cases on track. Is there a proposed order in there, or?
It should be there, but
I'm opening it right now. I just saw
Okay.
that it was there. There's your service, there's your sailor. You got it? Okay, he's got it. We're good to go. Okay, 23 SV 83 JP Morgan versus Brannon.
Carla Keith for that one as well. This case settled and we have a stipulation waiting, signature.
Okay. Right. Wait, whose signature are you waiting on?
Judges, we
Mine?
filed the order, yes.
Okay. Let's just make sure we have it. There's the motion. Mhm. Oh, and there's the order. It was signed by. Oh, okay. So just to make certain of it, so you have the consent stipulation for settlement, but then the motion is not a consent, I mean, the order is not a consent order or a consent motion. Anything I should be concerned about with that?
No.
Okay.
No.
Because I see where it's attached.
We just have the order there and we just attach the terms.
Yeah. And the only reason we're asking is super technically, and I'm sorry, it's a little academic, but because it's not a consent motion, I very technically am supposed to wait the 30 days for the response. What's saving you at this moment is I have an indirect signature from Margaret Brannon saying she consents to the stipulation. And so I can kind of make that leap and then just see, but in the future, if you don't mind just filing it as a consent motion, I can dispose of it right now and we can be done. So I'm gonna dispose of this one. I'm gonna make that leap. If she makes some noise, I will withdraw it and we'll have a hearing or whatnot. But if you'll just ask your team to just do it as a consent, that way I don't have to wait the 30 days. So.
Okay, I will.
All right, so I'm gonna put, to sign order for settlement. Does that work? Okay. All right, 23 SV 106, Bank, Discover versus LOSA. That's you, Mr. Wright?
Clayton Wright for that one as well. Same announcement, but I think you're gonna dismiss it.
Okay, well, let's make sure we hasn't been refiled. So that's always my big fear. Because I don't want to shut somebody out. I just got to keep my docket clean. No, I don't see a previous. No, it has not been refiled. So this is your first year with me. So, so I'm gonna, it is a no service. I'm gonna dismiss it for lack of prosecution. So you got the 6 months from here, plus frankly, a good year after you file it to get that person served. So, sorry about making you file another filing fee. All right, back to 23 SV 110 Goldman Sachs versus Mary Davis.
Clayton Wright for the plaintiff, same announcement.
Okay. All right, let me look and see if Mary Wright, Mary Davis, sorry, Mr. Wright. What's your middle name? There's a lot of Mary Davises.
Starts with a D.
Has not been dismissed and refiled. So, okay. So yes, I'm going to dismiss that one. It seems to me from the file that you're clear to refile. All right, Citibank versus Jester.
Carla Keith for the
Okay.
plaintiff, and we filed a motion for default in that case.
Great, I see it there. You have the order? Yeah. All right, so he's got the order. I've got everything in the file. We are good to go. I'm marking this one as on track. And Mr. Wright, just backing up to you, I know I said this a minute ago, but just say it again. If there's any process servers that would assist you and when you file these back, just let us know. And we'll be happy to help get process servers for you that would help you find your people better.
Okay, thank you.
Okay, 23 SV 146, JP Morgan Chase versus Daniel.
Carla Keith for the plaintiff in this case. This one's on for no service. We were asked for a continuance, but if it hasn't been filed, hasn't been refiled before.
Okay, let's check. So it's definitely in the no service column. I'm looking for Christy Daniel with 2 L's. No, it is never, there is no indication of any previous cases that have been dismissed and refiled. So
Okay.
I'm going to dismiss this for lack of prosecution. You get your 6 months plus another year, basically, once you get there. Okay, on to 23 SV 160, Auto Vest versus Fletcher. So they renamed our Tyler Technologies, who runs our database. They've got the majority of court databases in Georgia, and their database was called Odyssey, which I always thought was funny because an Odyssey is a trip where you work very hard to go to a place that you never get to. And then now they've renamed it to Justice. So now I get to say things like Justice is slow today, and Justice has crashed, and they don't think those jokes are funny, but I do. So. Okay, now it's open. There we go. It's in the no service category. Nobody's announcing on it. So I'm dismissing 23 SV 160 for lack of prosecution. All right, 23 SV 172. LVNV funding versus Hassie. Looks like there was service. No, old service. No, it's just a blank. There's no service. It's just a blank service form. Okay, so it's a no service case, and I'm dismissing it for lack of prosecution. All right, next case. 23 SV 179. It looks like there might be service. Maybe. This is Citizens Bank versus Banford. Yep, just served on June 24th, 2024. A notorious service. There we go. All right, notorious service on track. Anything on that? Mm-hmm. So this will officially move to the December calendar unless something else happens. All right, 23 SV 241, Georgia United Credit Union versus Miller.
personal service was, actually, I can't tell if that's personal service or a non-est. Oh, it's a non-est, okay. Debbie, will you just take a note of 23 SV 241? I want to point out something on that you and I could talk about, maybe clearing up a little bit. Okay, so it's a no service. Nothing since then, so I'm dismissing 23 SV 241 for lack of prosecution. All right, 23 SV 262, One Main versus Banks. A process server was appointed last year. No action since then. So it's a no service. Nobody's announcing today. It's dismissed for lack of service. Lack of prosecution. Okay, 23 SV 288. LVNV versus Middleton. It says defendant was served on September 5th. That's all correct. No action taken since then. Okay, so it's in default status. I'm dismissing it for lack of prosecution. All right, next case, 23 SV 289, LVNV versus Patoja, Pantoja. All right, it is a non-est, so no service, no action. I'm dismissing it for lack of prosecution. All right, 23 SV 292.
Here for the plaintiff, Your Honor. Same announcement.
Okay, let's see where that went. I already tried. Let's see. Confirming. Okay. All right. So I'm going to dismiss that one. But I just want to, again, make sure you know that we will assist you in any way that we can moving forward. Yeah, she got all the defaults, so all she had to do was file the motion for default. You got all the tough ones with the no service. So just saying, whoever dealt y'all the deck of cards this morning did y'all wrong. So, all right, 23 SV 313, LVNV versus Andrews. Oh, that's another of the same defendant, Fallon Pachoya, also known as Fallon Andrews. But that's not yours. We skipped it. It says in the file that they were personally served, but when I opened it, it says they weren't. So, so it's actually a non-est. It's no service. I'm dismissing it for lack of prosecution. Okay, 23 SV 323, Midland versus Warburton. All right, it's a no service. No action since December of '23, so I'm dismissing it for lack of prosecution. All right, 23 SV 330, Seaford versus Ward. All right, it says the defendant was served personally on February 15th. No action since then. Okay, February to August. I'm dismissing that case, so it's in default. And I'm dismissing it for lack of prosecution. All right, 23 SV 335, Barclays Bank of Delaware versus Daniel.
Here for the plaintiff. I believe a motion for default has been filed, and I have the order right here with me.
Excellent. I finally get to give you what you want. So let's make sure we have that. All right, Mr. Wright. Excellent. So everything looks great. Jordan, anything else? Well, he's got one there, so I guess so.
Actually, I thought this was an order. This is just the motion. So.
Oh, okay. Oh, he's got it. Yeah, y'all emailed it. So, all right. So I'm going to put default filed. Case is on track. So it'll technically, I guess very technically it goes to December, but I'm sure you'll get it resolved before then. So, okay. 23 SV 358, Marine Federal Credit Union versus Gonzalez. Okay, so it's a no service case, no action whatsoever. So I'm dismissing 23 SV 358 for lack of prosecution. Okay. 23 SV 362, Chase versus Murphy.
Your Honor, Kelly Callahan on behalf of plaintiff.
Okay.
We filed on Wednesday, Your Honor, on the 31st. We filed a motion for default judgment, and I have a proposed order if you would like it.
Great. Let's just give it to Mr. Hope one more
May I
time. Yeah, you go. Great job. Thank you. All right, so I'm going to put it as on track.
And Your Honor, I have no further business, may be excused.
Okay, I realized you had just the one. I'm sorry, I thought you had several, so.
That's all right, I got some other stuff done.
Okay, well,
Yeah.
thank you very much.
Yeah, thank you. Nice to see you.
All right, back to you, Mr. Wright. 23 SV 365, Discover versus Hubbard.
I believe the motion for default is filed this week on that one.
Good job. There it is. Excellent. So default's filed. You'll have emailed a proposed order, Mr. Hope. So great job. Glad I got two for you here, Mr. Wright. So.
I got a mixed bag.
Mm-hmm. On track. Great job. Okay. 23 SV 386, Marshall versus Johnson. Just dismissed? Great. All right, dismissed by the plaintiff. All right, 23 SV 389, Citibank versus Blue.
Carla Keith for the plaintiff on that one. No service.
Okay, let's see what we got. me search Blue in my system and see if there's been any refiles.
Okay.
Okay, no previous cases with Jared Blue. So,
Okay.
so I am going to dismiss this one. Again, you'll get my full support when you refile
Okay.
to assist you in any way possible. All right, 23 SV 390, Goldman Sachs versus Dykes. Mr. Taylor. Last action is a non-est, so it's a no service case. I'm dismissing that case for lack of prosecution. Okay. All right, 23 SV 404, First Investors versus Ford. There's a motion for default file. Okay, looks good to me. All right, so on 23 SV 404, I'm gonna mark that case as on track. And that the default has been filed. All right, 23 SV 407, Citibank versus Cole. Goodness, look at all those affidavits of service. Okay, personally served. I don't know. It's really weird. Maybe they just really wanted us to see it. Is that weird to you, Debbie? That's.
They had to have filed it so many times.
Yeah, I have 1, 2, 3, 4, 5, 6. 6 notices of filing. I mean, notice of service.
They must have been trying to figure out that you filed.
Yeah.
I don't have any.
They're all dated within a day of each other. I mean, that's the thing. I'm doing the filing fees on that in my head. Okay, well, that case is about to go away. That's a lot of wasted money because it's in default and no one's filed the default. Oh, fine. Okay. All right, I'm dismissing that case for lack of press. On 23 SC 407. All right, 23 SB 409, Citibank versus East Hope.
That's Carla Keith for the plaintiff. Is that number position 46 or?
Actually, I just opened it. It's got, yeah, there's a default in there.
Okay.
It looks like filed from your office.
Okay, yes.
Yes, it's from your office. And everything looks good. So, okay. All right, good job on that.
Thank you.
On track. Okay. 23 SV 410, One Main Financial versus, looks like Ziliac. Appointed a process server, many months ago, no additional action. So it's a no service, and I'm dismissing 23 SV 410 for lack of prosecution. All right, 23 SV 413, Prestige versus Webb. They filed a motion to appoint a process server. That'll work. Okay. Let's go off record real quick. All right, so I was looking for some action in this case, and let's go back on record. And there's a motion to appoint a process server that was just filed that I'm gonna grant, so it's gonna give this person a little extra time. All right, so I'm gonna put that we're moving this case from here to December, so the new process server can have a minute to try to find this person. All right, process server, motion filed. All right, so we'll grant that. Technically, this case is moved to December. December will be the final stop for this case. It'll either be served or dismissed in December. Okay, next case is 23 SV 421. It is a no service. There's no action whatsoever. Accelerated inventory versus Jensen is dismissed for lack of prosecution. All right, 23 SV 422.
I'm here on that one, Your Honor. This is up for no service, but the defendant is making payments to my client.
That's interesting.
Yeah, so we want to request additional time to serve that, and they haven't returned the agreement either.
That's a fascinating situation you find yourself in. So they haven't signed the agreement and they haven't been served, but they're making payments on it. But you can't track back the payments to serve, obviously, or you. That's interesting. All right, I'll move that one to December. That's a weird one. Everything in me is telling me to dismiss it, but I am assuming that you're about to file a motion for a process server, and I'm going
Yeah.
Don't tell anybody I did this. All right, so I'm going to reset it to December. That will be the last spot that it is. So it doesn't matter where it's at unless we got service and forward momentum in December, I'm dismissing it. So our December default no service calendar, where we just sweep up everything else, will be December 13th. Friday the 13th. Sorry about that, but okay. So
I believe that's my last case.
okay. All right. Well, Mr. Wright, if you want to stick around a minute, you're welcome to. If you're ready to go, you're welcome to go. Either way, I've got 2 more cases and then I'm done. So
Y'all have a good weekend.
thank you. You too. It's good to see you, Mr. Wright.
Good seeing you too.
I got to make a note of that. So defendant paying, but not served. All right, 23 SV 423, Citibank versus East Hope.
That's me, Carla Keith for the plaintiff. We should have filed a motion in that case.
Debbie, will you check to see if it's in your hopper? I don't see it on the, if it's been filed but not approved by the clerk, I can't see it. Sorry. Oh, okay, so it's not on my database, but what
Okay.
you heard me just say is that if y'all filed it, like let's say y'all filed it
It's
20
probably
minutes
last.
ago,
Yeah.
the clerk could be able to see it, but I can't. So,
Okay. And if not, I can get it refiled if I need to.
Yeah, she's checking, so we're good. All right, is this last one yours, 23 SV 425?
That's not me.
Okay. All right, let's see if that's a default or a 425. Oh, it was just dismissed. Dismissed without prejudice. Okay, so there's no action to take on that one. Let's let her check that real quick, and just make sure. Okay. All right, so just contact your office.
Yeah, we can get that filed today.
Okay. How about this? If I open up the file on Monday and there's nothing there, I'm gonna dismiss it. So.
Yes. I know I approved it and it's signed, and so I'll get to the office and get it filed.
Okay. All right, then I'm gonna say that concludes the calling of all three of our